I've learnt over the decades that you have to embrace the concept of compromise. When I was younger, there was no compromise. You can't give up. Now I've educated myself and clients to understand you're not giving up, but you're making a sensible decision for yourself to compromise.
What happens if we expect you to connect? I'm saying to you, Patrick, I sent you 3 emails on Sunday. It was urgent.
Yep.
And you didn't respond to me, and I'm really unhappy with you. What recourse is there?
If the employee suffers some detriment, the employee would have a right to issue a dispute.
What are you seeing as the key issues that are coming up regularly now?
One of the key issues is the actual collection by employees of their true entitlements.
If you're employing people or you're thinking to employ someone, there are certainly some key things you need to know. I've invited Patrick Mullally to have a discussion around what's happening, what's current, what's coming up, some of the issues he sees, and a whole range of other topics which I reckon are pretty interesting. So come and have a listen. What have you seen over the years? You've got lots of years of experience in IR and IR law.
Well, I think the biggest observation I would make would be that it has come from a very employer-dominated conservative model to a more flexible employee-related model. I think you would say in the modern era, certainly as I mentioned in the Albanese government era, there has been a huge shift across to employee rights. So the pendulum has swung, and probably some employers would say it's swung enormously in favour of the employee. But I think it's more of a correction of the imbalance that had existed historically.
Mm. What are you seeing as the key issues that are coming up regularly now? Because they do shift over time. What are you seeing now?
Well, I think at the moment, one of the key issues is the actual collection by employees of their true entitlements. Some of the awards are quite complex, and you need to have a dedicated and well-trained team to interrogate the payroll system. And so we're finding big companies like Woolworths and the banks have discovered that maybe over a number of years, many years, they have not been paying correct entitlements. Mm. And so there is, at the moment, I would think, a fairly big overview, particularly by the Fair Work Ombudsman, who is the regulator in that area, into the actual entitlements being provided to employees. And often employees were completely ignorant of, maybe some overtime, or maybe particularly penalties for weekends, shift allowances, uniform allowances, laundry allowances, all sorts of things which are not huge amounts of money in themselves, but over 12 months or over 2 or 3 years, they amount to quite a lot of money. So we're finding a lot of self-regulation going on, particularly in the big companies, now that the Fair Work Ombudsman has been involved in alerting companies to the need to have a look at their award coverage and exactly what those entitlements are. So I would think that that's probably one of my big observations of the current modern industrial landscape, that the correct entitlements are being chased down and paid to employees. And that's probably maybe has become more important because of the cost of living crisis, the increase in rents and cost across the board has probably made people more alert to whether they're actually being paid what the award or the EBA agreement prescribes that they should be paid.
And in your experience, and you've seen this in and out of the Fair Work Commission, do you think generally that discrepancy is conscious, or is it? Are they just oversights? As you said, we don't have a team that understands the complexity of it, and things were missed.
I think, broadly answering that question, it's oversight. There will be a niche of probably, I don't want to be judgmental or critical, but there'll be a niche of smaller companies who it's a combination of oversight and, well, you know, that's the way we do it here, rather than consciously, independently getting outside advice to say, well, what should they be being paid? Whereas in the big companies, it is probably institutional malfunction, oversight, and they are very conscious. And even in the last few weeks, there's been reports come through where they've self-regulated and reported to the FWO that they've underpaid, and
that's pretty good, really, isn't it?
Oh yeah, excellent.
To say, well, they're not hiding anything, and they've discovered, look, we've admitted to do this, we've made a mistake, and we're putting our hands up to say, hey, we've done it, but we'll make
That's
good.
right.
Yeah. Actually, that that says some quite good things on behalf of the employers in trying to honour their commitments to their employees, if that's generally correct.
Yes, yes.
Good insights, because you never know. Unless you're in it, you don't know what really goes on.
No, that's right. And the other thing, though, is that you can be in it, but sometimes you become so, I don't know, is it busy or overwhelmed by the system that you don't get air to look at the broader picture? A lot of those questions you asked me made me self-examine, hang on, have I been paying attention to that? Because I go to work every day and toil away and, see 3 or 4 people, answer 100 emails, deal with deputy presidents at the Fair Work Commission who want to have a conference at 4:30, and if you haven't put your paperwork in by 3, bad luck, you won't be able to come. So you get really immersed, and you don't start thinking, how is all this planning out in the real world? And as you said, how is it affecting our productivity and ultimately our standard of living and our way of life? They were good questions to stimulate my brain for the future.
Thank you. And it does, that genuinely concerns me, because it's always the person who works for a living who pays the price for everything. And when, it doesn't matter whether it's a business group or a union group, when they have their own agenda, I'm not certain that anybody's really got the person who has to live with this in 10 years' time at heart.
No.
It's driven by agenda, and that really bothers me. So I keep bringing it up. And hopefully a few more people might listen and get on board.
Yes, I think it's a gradual process. And always, I've learnt over the decades that you have to embrace the concept of compromise. When I was younger, there was no compromise. It's straight on. We get this, or we can't give up. Now I've educated myself and clients to understand you're not giving up, but you're making a sensible decision for yourself to compromise, because you've reached this, and this is in the miniature, of course, it's individual, but you've reached this point where you can achieve a certain amount of what you wanted, and protect yourself from any further ongoing grief or exposure to the people you don't like. Do you want to be in a lot of people say to me, at this conference, do I have to be in the same room as them? And I say, yes, you do. I said, but I do the talking, so you can just go to sleep if you want to, as long as you're there to give the answer, are you going to take this or not? And then I say, if you're frightened of going, or not frightened, it's not the right word, but if you are uncertain about being in the same room in a conference, do you think about what it's going to be like if you don't resolve this and you have to go into the full-blown court case, where not only will you be virtually rubbing shoulders with the people you don't like, but you'll be in the witness box and they or their lawyers will be asking you awkward questions about this case. And don't forget, they've got a completely diametrically opposed view of who's right and who's wrong. So you're going to have to do that. No, I don't want to do that. I said, well, when that means that we're going to have to compromise at this early stage to protect you, but to give you victory in a certain way that will be reflected in a deed, and it's confidential. They can't talk badly about you. Oh, yes, they will. No, they won't, because when they sign that deed, that's a contract. And if they do talk badly about you, you can take them to court. I know you don't want to go to court, but you do have that right, and you would recover substantial damages if you, for example, didn't get a plum job with BHP because they bad-mouthed you. So that concept of compromise is just so important. And I often have this debate with various members of the Commission, Fair Work Commission, and even those who are from the employee side, and there's been a few of those appointed the last few years, they do push for compromise because they've come from the union and they can see the advantage of, it can be all-out war, but what does it achieve for the individual at the end of the day if they're emotionally and financially exhausted and don't win? Because that's always the risk. If you're going to the umpire, you're going to get an answer one way or the other.
I've heard some very complimentary things about the conciliators at the Fair Work Commission. In fact, I've heard a number of things and they're all complimentary, even when people I've spoken to haven't got the outcome they wanted.
Sure.
The feedback's been overwhelmingly very positive to say, well, I didn't like what they said, but you know what, there was truth in it. And
it made sense.
Yeah, I still don't like it, but I can move on and I can accept what they said.
I've got closure. Closure is so important, yeah.
I love the way you frame that. I wish you could bring that to the family court system and that thinking.
I've been in the family court system.
Have you?
Oh, yeah, many, many, many years ago. And God bless Gough Whitlam, but he would turn over in his grave if he knew the complexities of the family law system, because I also lived in an era before the current Family Law Act, and it was this is called the no-fault family law, right? Before that, you had to find fault. So you had to have investigators out following your partner, and springing them in bed and to prove adultery, and all that. It was a terrible jurisdiction. So Whitlam reformed all that, brought in the Family Law Act, user-friendly. You can do it yourself. You don't need to spend money on lawyers. Go to court, get it sorted out, no-fault divorce, and hopefully you can work out who's going to have the kids and how the property's going to be split up. Well, it started out with good intentions, but boy, in that first, I was only in it for probably 10, 15 years. But it has just become a minefield of law, legalities. And from my reflection from the back room, looking at it, hearing it from colleagues and various people. So, yeah.
If somebody could bring the way you framed compromise in that conversation, if somebody in family law, if the lawyer were happy enough to frame that conversation with their clients, I wonder if they'd all get a better outcome. The lawyers' fees would be less, admittedly, because they're saying, we're better off not going to trial.
Yeah.
How about we genuinely try and sort this out between the parties, and we'll charge you for that. But imagine what this would be like if it goes to trial.
I think family law, of all the legal disciplines, seems to be so infected with emotion that the lawyers, from a young age, become emotionally attached to the client and sort of assimilate their attitude to the other partner, the other party, their former partner or spouse. I remember years and years and years ago, I had this lady who was going through a divorce, and she was ringing up incessantly. You had to take at least 10 calls a day. And she'd ring on a Monday and say, "Oh, you won't imagine what he did on the weekend when I was trying to, get the kids ready for access. He came too early and he was, said something rude or whatever. And what a beastly man, an awful person." And I used to say to her, "But look, Julie," or whatever her name was, "Julie, you're in a divorce litigation. You've separated. So obviously you're not going to see him as a nice person. I think you've really got to get your head around that and stop worrying about that, because that's why you're in divorce." But no, she wanted to. And I think that's sort of, it probably needs a lot of psychological analysis of the whole system, because it and look, I can raise the same criticism of the Fair Work Act. When work choices came in, and that was a Howard initiative, and then Rudd pushed it in the Fair Work Act, and on it's gone. It was supposed to be very user-friendly. In fact, lawyers can't appear without permission of the Fair Work Commission, so part of our daily work is to write submissions about why this person should be represented, and it's pretty well a formality if the other side is represented. And I do most of the work for employees, so 9 times out of 10 the employers are represented by law firms. I'm often dealing with Baker and McKenzie, who international law firm. So representation's not an issue, but the law of the Fair Work Commission is evolving daily, and one of the great things that I've been able to see is the rhetoric that has gone on over the years that in the Fair Work Act, reinstatement to your old job is the primary remedy. That's what's supposed to happen. If you lose your job unfairly, the law is that you should run your unfair dismissal case. Yes, it was an unfair dismissal, and therefore you should get your job back. Compensation has been set at a low level because it's not really considered to be the primary remedy. And there's a cap of 6 months, as you probably know, on unfair dismissal compensation remedies. But the number of times historically when you got reinstated is very, very rare. The figures produced by the Fair Work Commission, particularly at conciliation conferences, they say, "Patrick, you know that there's only 1% of people get reinstated." I said, "Yeah, I know that, but it's still the primary remedy, and the reason they don't get reinstated is they don't ask for it. They don't want to go back to this old
Yeah, well,
employer."
why would you? It doesn't make sense, right?
Doesn't
It's
make
like
sense.
saying in the family court, I'm getting divorced.
But I'll
The
go
primary
back.
remedy is, let's get back together again. Yippee, let's do that. What a
So-
great solution.
But with the big employers, getting your job back is very easy. If you work for BHP, Rio Tinto, or in New South Wales, Sydney Trains is a big employer, very big employer. DP World in Sydney on the docks, very big employer. Who's the other one? Sydney Ferries, another big employer. In the Fair Work Commission in the last 3 to 4 months, there have been 3 or 4 full bench decisions where employees have been reinstated and in those companies. And they are setting huge precedents for safety issues. And there's 3 cases on alcohol and drug policies being breached, and a huge shift to finding that dismissal on those grounds in those circumstances was harsh.
For alcohol and drugs?
Yeah, breaching the alcohol and drug policies.
Wow.
And in some of these companies, and in these particular companies, I'm generalising a bit, but the policy of drug and alcohol was written in some parts in a punitive way, but in other parts in a rehabilitative way. And the Fair Work Commission member, first instance, latched onto the rehabilitation and said, well, your employee was expressing mental health issues. The reading was not hugely excessive. It was in breach of your policy, but he could have driven a motor vehicle and not been penalised for it on the road traffic regulations. So I think that you should have offered him the rehabilitation provisions of the policy, given him a warning, and eased him back into work. I mean, we're talking about employees of 20 years standing. So
Okay.
there's a
history.
In days gone by, it wouldn't have mattered. You breached the policy, that's it. Unfair dismissal, don't even think about it. So the reason for all this long-winded speech is that there has been a huge shift in arguments about reinstatement. And I've just yesterday finished submissions where I said, we're not seeking compensation, we want to be reinstated, and the law is that we should be. And this guy worked for a smallish mining company, but big enough to be able to be reintegrated back into it. He's been there 6.5, nearly 7 years. So he was quite aggrieved, and the grounds of his dismissal, and I've said in the submissions, I'm citing these drug and alcohol policies cases, which are very serious breaches of safety. My guy, no safety breaches, 7 years of a clean record, had a minor quarrel with his supervisor and got the sack. I said, it doesn't add up. So reinstatement, please. So we're yet to see. But often, though, my push for reinstatement is to tell clients that if you want to maximise your compensation, you need to let the employer think that they're going to be saddled with a reinstatement. And it worked against one of the big mining companies quite recently, where, they came back and, because my submissions were like that, went, not interested in money, we just want the job back. And on the court door they said, well, what about 6 months' pay? I said to my guy, 6 months do it? He said, yep. Where do I sign? So, he was there for 24 years. Very sad case, really. But, the experience sort of said, no, I don't need to go back. I can find my feet somewhere else. And particularly, I said, look, if you get the non-disparagement and a statement of service from a big miner and says that you resigned and left because you want to shift to Perth, makes sense.
Talk to me about the SME landscape, Patrick, because that's big end of town, but a lot of us live in the small and medium enterprise sector. And what are the things you see that we're dealing with there?
Look, I think the smaller enterprises have as much difficulty navigating the industrial landscape as do employees. And when I say employees, there are two probably main groups. The first group will be those who are members of a union, and then the second, which is the greater majority, are not members of a union, so they are really doing it alone to see what their rights are, what their rights are with respect to unfair dismissals, terminations, probationary periods, fixed-term contracts, and all those sorts of things. But the small to medium-sized employers, they are equally, I think, troubled by how do they ensure that they are compliant with the new regulations, with the new landscape, and they often will not have sufficient resources to have a dedicated HR department or human resources, IR specialists on board, and so they will need to either upskill somebody, one of the directors, or go outside to independent advisory bodies. So in my experience, the small, particularly the smaller businesses, those that they're defined in the Fair Work Act as having less than 15 employees, they do, I think, have an equal difficulty navigating the evolving Fair Work Act and the various awards and changes to the awards. One of the most recent things, of course, for small business is the right to disconnect. That came in on the 26th of August of this year. Larger companies that had been imposed upon them a year earlier. And that's quite significant because a lot of the small businesses tend to be run like a family group. And
they are a family, really.
They are a family
lot of the
group.
small, if you've got 5 employees,
sure,
you know everyone intimately. The line of communication is direct.
Yep.
There are no layers of management. And I've found employees equally treat it like family.
Yes. So when there's a rule, the right to disconnect.
Can you tell us about, what does that actually mean?
Well, that means that once the employee has completed their hours of duty, whether that be 7.5 hours a day or whatever it might be, if it's part-time be less or casual, they are then free from having anything to do with the employment relationship really, which in the small business I think goes against the grain to a fair extent because, as you say, there'll often be a true family as a business model, or the small business has become a family and that's the way it's run. But having said that, though, the right to disconnect, you can agree to be contacted after hours. So if the employee is comfortable with that, there's no problem. But I think...
So it's a right rather than a...
Yes.
Yeah, so...
You've got to be... The employer needs to be mindful of that, and I would recommend the small employers to negotiate that with each of the employees, and there may be, we'll only get in touch when there's an emergency.
Yep.
Or something's crucial and so forth.
Yeah,
so,
and are you okay with that?
Yeah.
So if you're working for me, and
Yep.
Patrick, we've got this going on. I know you finish at 5, but there are a few critical things. Are you okay if we reach out if we need something?
Yes. I think that's how it will develop. Some of the feedback coming through the case law and the Fair Work Commission commentaries is that it seems to work. It worked fairly well with the first introduction with the larger companies. And I think if it's navigated correctly and probably I think the Fair Work Commission is trying to be more educational as well rather than simply being the body that enforces or enacts the awards, registers agreements, polices the negotiation of agreements and so forth, but to have an arm which is educational. In the modern era, of course, there's the websites and encouraging people to go to their website and getting feedback has this page been helpful and so forth. So, yeah, I think the introduction of some of these things will be assisted, particularly in the small business, by concentrated educational resources from the Fair Work Commission.
I think small business owners are, on the whole, pretty good. And they understand that for people to be productive, they actually need to rest. So I wouldn't imagine there'd be any real pushback. You know, there are always a few exceptions, a few outliers. But for the most part, I think people would think this is great. Would you see it any differently? You know, and you see a broader cross-section of what happens, probably on the worse end of the spectrum than what I would see generally.
Yeah, because we get to...
You get all the problems.
Where there's a problem, where there's a crisis, you know. You know, when you meet somebody, you're not sort of saying, well, I'm pleased to see you, or the client saying, I'm pleased to have met you. Some of them do, but of course it's in a pretty stressful sort of situation probably. But I think, yes, when you look at the statistics in the Fair Work Commission and the industrial courts generally, there would only be a relatively minor percentage of the employment relationships finishing up in litigation of one sort or another. Obviously, the unfair dismissal regime is the most commonly heard of and utilised, because every employee, when they feel they've been wronged, will resort to the Fair Work Commission's website to interrogate what unfair dismissal means, or they might talk to someone who says, oh, that doesn't sound right to me, you better get some advice or do this and so forth. But by and large, when you look across the employment landscape, the breakdown would only be in a minor percentage.
Can we talk probationary periods for a moment?
Of course.
So I've been told that technically probationary periods per se don't exist under the NES. There's a limit of time if you've got 15 employees or less where you can dismiss a person without having unfair dismissal held over your head. And even though they're written into contracts, they're not necessary. You don't need to write a probationary period into a contract anymore. Is that actually real?
Well, I think the way that you're expressing that, and if is relates back to the minimum employment period, which is a jurisdictional basis for being able to bring an unfair dismissal case. For employers employing more than 15 employees, it's 6 months. For those employing less than 15, it's 12 months. So you're right that during that 6-month period for the large employers, or the 12-month period for the small business employers, you're able to terminate the employment relationship without any risk of being taken for an unfair dismissal. So in many ways the probation period is, although traditionally in most employment contracts that I've seen, is in a sense duplicating or an overlay of what the rights would be emerging from the relationship going forward. Although properly used, I think a probationary period enables both parties to review at an early stage how the employment is going, rather than saying, oh, look, the minimum employment period is about to expire, we better have a look at whether you're going to stay here or not. I don't think that's the the mental approach from either party, really. I've never heard of anybody actually coming in saying, "Well, they got rid of me just before the time was up." It's more like my probation. I wasn't successful in my probationary review. Now, whether that's at the 6-month point or the 12-month point is debatable, but really, properly used, a probationary clause should get the parties exchanging views at a fairly early stage in the contract.
That's how we used to use them.
Yeah.
And it really was a genuine opportunity by contract for each party to review each other, because as much as we could say, well, dear employee, even though you've said these things and we've reference checked you, we don't know whether you can deliver. And you only know when you actually go and do it. And equally, you're just hearing from us, our culture is like this, we'll do this for you. But you don't know. So it's an opportunity for us to get together, do some work and actually see how it goes.
Exactly. And a lot of going back in the earlier days, two decades or so ago, you would find the commission or any tribunal looking at that relationship describing the probation as being an extension of the interview process. So you put your application for the job, you fulfil the job description on paper, you talk through it with the potential new employer, and you start. But that interview process is going on as you actually work on the job, and that's what probation looked like. It just so happens that there is now in the unfair dismissal space these jurisdictional foundations which give employees a right to an unfair dismissal once they've been employed for a certain period, as I've said, the 6 months or the 12 months. So in a sense, that has legally usurped the probationary period. But if you let go, to use the common phrase, if you let go during the probationary period, which will inevitably be less than, some of them are 3 months, or maybe they are 6 months. If you let go during that period, you will know that it hasn't worked out, and unless there are very serious reasons why you were dismissed during that period, you don't have the employee hasn't got any substantive legal rights to challenge it. But there are what we call, you may have heard of the general protections provisions of the Fair Work Act, which is an area which is quite difficult to navigate for employees, because it only commences in the Fair Work Commission and they have a power to mediate, and then it has to go off to the federal court, or the parties can agree to let the Fair Work Commission do an arbitration on that general protections case. Now, general protections arise because you have been terminated for an unlawful reason, and broadly speaking, that is enshrined in having, if you're exercising a workplace right, which is another big area of disputation, because one of those workplace rights is to actually, in my opinion, and there's not a lot of case law on this, but in my opinion, one of the workplace rights as defined is to be actually able to do your job. And this arises quite uniquely where you have a senior safety officer, for example, in a safety critical industry like the mining industry. So the safety officer will have not just his employment obligations, but he'll have obligations under work health and safety legislation. He may well be defined as the mines manager, which carries huge responsibilities under legislation. And let's imagine, and I've run these cases, let's imagine that the safety officer prepares a report, complains to the CEO and the board that there's a safety issue on X, Y and Z mine site. We need to act immediately. CEO comes back and says, safety officer, we don't have the money for that, but the board and I have decided that you probably should go. Now, he might be in a period when he hasn't got the right for an unfair dismissal, or, more importantly, he may have been there for a while, but his salary is such that he's prohibited from doing an unfair dismissal.
Oh, what is that?
The threshold.
What is that threshold, Patrick?
The threshold at the moment is $183,000.
Okay.
So you can imagine safety officers in a big mining company are probably on 300,000 or 400,000. So they have to really interrogate the reason why they terminated it. It won't be as open as I just described.
Sure.
It'll be more subtle. But in my view, that is a workplace right to actually perform your duties in accordance with the law and your employment contract. And if you finish up being terminated because of that, I would consider that to be a very serious breach. But it is certainly something which really needs to be reformed insofar as the actual prosecution of it, because dealing with employment-related issues, you don't want to spend a couple of years in litigation not knowing what your status is arising out of your last job. You want to get on with your next job.
Yep.
And hence, the Fair Work Commission in the unfair dismissal regime has a KPI of 2 months after hearing for delivery of the judgment, and they're expedited pretty well. The expectation is that from the date of dismissal until the outcome of a hearing wouldn't be more than 6 months, and usually it's much less than that, particularly those who get resolved by conciliation. So your problems could be over in 2 months, compared with 2 years, and leaving aside the cost.
Yeah, of
course. Prohibitive for the average employee, unless you've got the union backing, to go to the federal court is pretty well out of limits.
But it is a long time out of your life, isn't it? Yeah. Any court proceeding.
Yes.
It's not just a litigation. It is an impact on your humanity to some degree, isn't it?
Yeah, it's a huge emotional burden, and affects family life, marriages, children, economic status. All of those go into the mix. So, in many ways, I often consider the employment relationship to be not that much different from the marriage relationship. When they break down, it's a really huge psychological burden, emotional burden.
Interesting. Can we talk about working from home?
Sure.
Because that's come up in conversation so many times in the last probably 3 months for me. And we have our own version of you can work from home. But I'm hearing from lots of employers a reflection on productivity now. They're saying, well, people have gotten used to working from home. They like to do it. We don't actually mind them doing it. But we're becoming more and more aware of the real productivity cost. And we're finding that people are more productive when they come to the office and less productive. This is a generalisation, less productive when they're working at home. And it's not hard to imagine why. I don't think it's for everybody, frankly. That's a personal opinion. What are you hearing and seeing in that realm?
I'm hearing and seeing a greater push for people to be allowed to work from home. The Fair Work Commission is obviously seeing the same push and urging, and is now conducting a review of across the board of the awards. I think that's set down to take probably another year or so to go across the board and get feedback. The way that the Fair Work Commission operates in these areas is to undertake research, invite submissions from interested parties, the main peak bodies on either side of the employment space, and do its own research, and then have hearings into the actual amendments to the award to, for example, bring in the right to work from home.
Does somebody want it to be right?
Sorry?
Does somebody out there want working from home to be a right rather than an option? Is that a thing, or did I just latch onto a word that might have been misspoken?
I think there is a very small percentage of union members who would be pushing to make it a right. It's not. I don't think the ACTU has elevated it to that stage at this point, but yeah, I can see that there may be a push to, in certain industries, to make it a right. But of course, it's all flowing from our experiences during the pandemic and the lockdowns, where certain businesses wouldn't have survived unless their employees could have worked from home. So, I think we're picking up the aftermath of that, and I think it's been particularly attractive to women who, with perhaps small children, family responsibilities, and find that working from home enables them to keep working, whereas they may not be able to if they had to go into the office on a regular basis. So, yeah, I think to answer your question, there is I think across the board, a more awareness from the regulators to look at some oversight of it, so that employers and employees have some framework in which to work, rather than it being imposed and you'll do this and you'll do that. Much the same way as the flexibility arrangements put in place by negotiation.
I'll come back to flexibility. That's another interesting conversation. I wanted to touch on some of the issues that I think are present in working from home. I'm all for it, by the way. I think it's a good thing if there's an open conversation between employer and employee that addresses things like productivity. If you're less productive when you're working at home, that ultimately works for no one. Somewhere down the line, it's going to break. If you're not in the office a lot, you're a human being. And if you're isolated at home, whether it's with family or not, you're not going to hold the same culture as a group of people at the office. And if culture is important to driving a business, with a bunch of values attached to it, you are separated from it. And I've seen that in reality. In the pandemic, there'll be lots of examples of it. And you can't help it because we're all people. I think we see that as a major issue, and learning, because learning isn't just through training courses, as you know. If I'm sitting next to you and I'm hearing things, and there's short conversations, I'm continually learning just because you're there. And if there are 5 other people in the team and we're all there, we are learning together, and we'll laugh together, we'll feel together. There's a whole bunch of things that you'll miss out on if you're working on your own at home. Do you hear those sorts of conversations, or is that really not in the realm of where you guys live or talk about with your clients?
It's not primarily a huge topic of conversation, but it pops up on the fringes, and I'm from the old school. I don't believe in working from home because of the various matters you've just mentioned. That going to the work site, going to the work office, going to the team is all part and parcel of what the business is constituted by. And working from home, home's home. You have a different mindset, and I don't care what software an employer can impose upon your computer to see when you're logging on, logging off. When you're at home, you're in a different mindset. It's a different culture. But that said, of course, I can see great benefits for people being able to work from home, whereas they may not have been able to work at all if they couldn't work from home.
Yeah, look, I can see both sides of the coin. I think my concern long term is productivity when we think about competing with the world.
Yes.
We have high, and we want to maintain a high standard of living in our country. And we don't do it without being able to trade. So just trading domestically isn't enough. We need to compete internationally. And if we become more and more costly and less productive here, we won't be able to sustain it. So somewhere down the track, if we make poor decisions around these things, the next generations will suffer for it. And that's why, for me, this is a really important conversation. And I know as an industrial relations lawyer, it's not what you do day to day. I guess what I'm hoping is that sort of thinking may come into the discussions that you guys have or are involved in, because I would imagine your opinions are also sought when decisions are made in the Fair Work Commission. You or your peak bodies may be some of the parties at the table to discuss the ins and outs of whether decisions should be made or amendments should be made or not. Is there any truth in that?
Yes, of course. And I think the actual, even the litigation space, for example, in the Fair Work Commission, will throw up as corollaries perhaps to a major issue on a termination or a dismissal, and it will cause a sort of internal thinking and review in a small way when it starts being repeated across the board in a number of cases. So the case law, even though the individuals are quite small in the overall landscape of what's going on, those smaller issues will surface and bubble to the surface and be reviewed at a higher level eventually, yes. But I take your point about the generational significance of what we do, because I'm sort of at a stage in my life and career where I can look back on quite a number of generations and see how things have flowed on, and it's so. And as we said, I think very early in this morning's discussion, life is very short, and the generations soon develop and move into positions where they're inheriting the landscape or the regulatory system we left behind for them, and how that works and affects the economy, and ultimately, as you say, our way of life and our standard of living.
Can I talk flexibility agreements? That's part, and that's my understanding very broadly is that actually they're a very, very good tool that employers and employees can use, so they can come to an agreement and go, yes, we're both happy with that, let's move on. There are minimum protections in place because of the NES, and by and large, I think everybody's in favour of them. How do they work now? Are they different to what they were a few years ago, flexibility arrangements?
I think the flexibility agreements were at the start, a few years back, they were not sort of recognised by the employers, particularly in some of the HR people were slow to understand the availability of the flexibility agreement. But in more recent times, they are utilised, from my observations, quite regularly, and a good tool to have that arrangement between employer and employee, where you need some flexibility on both sides to work the business appropriately. And as you say, provide the restriction is that they can't go beyond the minimum employment standards and the award provisions reflecting the NES. So what
can you do with them? So let's say that the minimum benchmark is the award and the NES. So don't go below that as a starting point. Beyond that, what can you do in flexibility? What does it allow you to do?
What it allows you to govern breaks, govern overtime hours, and normal hours can be redefined in a certain way to suit the business. To have regard to what otherwise might be a penalty working relationship, to alleviate that with some give and take in the relationship, so that the employee is able to, for example, might want to work on a Saturday and use those hours as being normal hours that suits the employer, but he gets some time off during the week to reflect that.
So if I, let's say I run an air conditioning service and repair business, and one of my employees comes to me and says, well, look, I really want Fridays off. My kids are doing these things, and I'd love to spend more time with them, but I'm happy to work Saturdays. We could come to an arrangement where I would say, well, that's great, go spend time with the kids. That's an unreal idea. If you work Saturdays, though, we're going to consider those normal hours as if it were a Friday. So we're not going to pay you penalties, and that would be okay.
That's fine. Yeah, that'll be fine. Bearing in mind that agreement can be terminated by either party, given the appropriate notice, which I think is 14 days. But
yeah, which I think, my kids aren't doing that anymore.
Yeah.
Can I work normally and have my Saturdays off again? Go, yeah, fine.
Yeah.
Yeah. Are there any other things we should be careful of that have changed? So I've heard August 26th was the date that the, what did you call it?
Right to disconnect.
Right to disconnect
That's
came
a
in.
small business, yeah.
Yep. I didn't even know that.
A year before that, it came in for.
Yep.
And that has become an award provision, the right to disconnect, once your working hours are finished.
Yep.
So you don't get phone calls, you don't get emails. Well, you can.
But you don't have to respond.
But you don't have to respond. And historically, of course, on Mondays you got to work and the boss said, hey, I sent you 3 emails on the weekend, why didn't you answer me? Oh, I was too busy playing golf. Well, that's not our culture here. You're on a warning. So people were terminated eventually for not doing that extra. And it was the research that went through, particularly through the ACTU, found that there was a pretty big understanding by employers that it wasn't harmful to contact you out of hours. It was part of the values of our company. We expect you to give it all, even though you've knocked off. Mm. So that's been rectified. But in the event, of course, that the employee is happy to be contacted and has had a discussion with the employer, there's no problem with that.
I think that provides a good balance.
It does.
That feels right to me.
Yeah.
What happens if we expect you to connect and it's almost forced now, isn't it? We said, Patrick, you didn't reply to my emails on the weekend.
Yeah, that's
and
right.
I say, well, I expected you to, and you didn't. What recourse is there?
For whom?
For you as the employee. Because I'm saying to you, Patrick, I sent you 3 emails on Sunday. It was urgent.
Yep.
And you didn't respond to me, and I'm really unhappy with you.
Well, only if the employee suffers some detriment, the employee would have a right to either issue a dispute application to the Fair Work Commission and take his employer down to Fair Work, and Fair Work would be saying at a conference, Mr. Employer, that's not in order, you can't do that. He's entitled to dispute it. Even worse, if the employer said, it's all over. I'm not
Patrick, you're sacked.
You're
Get
sacked.
out.
I'm giving you notice, you're gone. So clearly that would be an unfair dismissal. Or if it was one of those dismissals which was jurisdictionally prohibited because of time, or because of the income threshold, you would certainly have a general protections case, because the right to disconnect is a workplace right. And if you've exercised it and you get sacked because of it, it would be very clearly a general protections case. So employers need to be fairly alert and educated to this. It should not be seen as something dreadful. It's something to be navigated and either respected or discussed with employees where there are the potential for an urgent contact out of hours, and an understanding with the employee that, fine, sure, just ring me, just don't ring me at midnight or whatever it might be.
It's just being decent to each other, isn't it, really?
Yeah. But it needs to be navigated on that basis and not left unsaid, because if it's left unsaid, the workplace right will kick in.
Yep, great. So I'm going to talk in SME land rather than big end of town. If I'm employing a new person, what should I be mindful of?
Well, I think the most important thing that emerges from a lot of the general reporting in the industrial scene is to be fairly critical and very thorough with respect to checking CVs and references, particularly CVs. Time after time we hear of, fabricated CVs being put in and people not checking them, just taking them on face value, and then ringing a couple of referees of recent times and say, yeah, Pat's a good guy, nothing to worry about there. But going back in the CV, if you checked it properly, no, he wasn't ever the CEO of the City of Adelaide. We didn't. That was 20 years ago, so we didn't bother to check it. But it's pretty significant when you read it.
Yep.
Wow, this guy is just the man we want. So that's a sort of not so much a legal issue. That's a business decision to be very, very thorough in that first vetting process. Then when it comes to the appointment, I think very thorough employment contracts, particularly in this day and age with respect to protection of IT, protection of privacy, non-disparagement of the employer and other employees in the workplace, confidentiality of the business and other employees' rights and privacy. So, a really solid written employment contract is paramount. The other thing that I often suggest is to look at a fixed term contract, because I often hear from employers, small employers, look, it was looking okay. We got to 6 months, probation was fine, looking okay. But then, after Christmas, it all fell apart. I don't know what went wrong. But what do I do now? I said, well, you've got to do performance plans. You've got to go through all that process. And these have occurred to me in the professional landscape, like accounting and law particularly. So I've often gone back to recommending the fixed term contracts. But the Albanese government has made the use of fixed term contracts of limited value now, because you can only have 2 renewals. So you might employ them for 1 year and then extend it for that next year. After that, they have to be permanent. But at least, it gives you a bit more than the minimum periods of the Fair Work Act.
Yep.
If you put a year in, at the end of that, if it comes to an end, you can say, look, we're not going to. We don't really have that position anymore. Hasn't worked out, so we'll have to shake hands and see you later. Contracts at an end. There's been a lot of litigation in the Fair Work Commission previously about whether that was the end of the employment relationship, and it's always come down in favour of the the contract. So that's probably a number of things, but goes back to the other question you asked me about, and I'm taking the devil's advocate now, for a new employer, he gets presented with a statement of service and a document which says he resigned. And when you try and go behind that, hopefully if the company's obeying the law, they will say, yes, that's exactly as it was. But in truth and in fact, you're about to employ a new person who got busted for breaching drug and alcohol policy. Fair enough, in circumstances which were deemed to be unfair, really, but nevertheless, the factual matrix being presented to the new employer, in my view, is somewhat skewed. Even though I settle cases every day of the week, and I've got to look after my guy, not the new employer.
Absolutely, yes.
But to go back to what you said, what should I do when I'm employing a new person? I strongly recommend going right through the CV back into history and checking out.
So vet people properly.
Vet them
Vet
properly.
people properly to prevent the potential for cost of any sort and unpleasantness and conflict later on.
Yeah, sure. Finally, I think, get good advice. It's a small price to pay, either on the HR side or on the legal side. But the HR, if you haven't got a HR practitioner in the business, go outside and get one. Get your contracts done thoroughly, and good solid contracts, so that both parties know what the responsibilities are.
Yeah, great. Do you guys do contracts?
Do I do contracts? No.
So you're just litigation?
Just mainly litigation, yeah, all litigation, yes.
Yeah, okay. So where do we find you? If somebody has an issue,
With,
they need to get hold of a good lawyer.
At Work Claims Australia.
All right.
Yeah.
And I'll ask good Jeremy over there to pop that in at the bottom as a link, if you don't mind.
I think I know that one.
Yeah, I'd hope so. Patrick, thank you for your time.
No, it's welcome. Thanks for having me.